Is there a different?
Oh, good day. Bonjour. The International Law Association of Canada is pleased to present current issues and trends in international intellectual property law, ILA Canada's noon hour panel on this topic. I'd just like to mention that this presentations are all going to be in English, but you are welcome to pose questions in French. Vous êtes bienvenue poser des questions en français et ça serait parfait. My name is Una Fitzgerald. I'm the president of the International Law Association of Canada, ILA Canada, and senior fellow with the Human Rights Research and Education Center of the University of Ottawa. I have the pleasure of moderating this distinguished panel. In keeping with Indigenous protocol and building respectful relationships between Indigenous and non-Indigenous peoples of Canada, let me begin by acknowledging the traditional territories of Indigenous peoples. We are meeting virtually across Canada and beyond, so I would like to acknowledge that the Indigenous peoples are the original occupiers, traditional stewards, and inherent protectors of the lands and waters called Canada today. We are grateful to live on, learn from, and enjoy this land and commit ourselves to decolonization in our personal lives, our businesses, organizations, schools, and in our communities. The commitments we make in this land acknowledgement must be actively pursued and come with a belief that decolonization begins with reconciliation with all Indigenous people, inclusive of First Nations, Inuit, and Métis people. If reconciliation is to be successful, we must continue to deepen the ways in which we listen to, learn from, and support Indigenous peoples and their resilience, resistance, and self-determination. So the International Law Association of Canada is the Canadian branch of the International Law Association, which is based in London, England, and founded in Brussels, Belgium in 1873. With over 4,500 members around the world, our collective objective is to promote the study, clarification, and development of international law, both public and private, and the furtherance of international understanding and respect for international law. Our membership is global and diverse, and our members provide a full range of international law services to state and non-state actors that help shape current socio-economic, environmental, and political contexts in which we live. Comprised of legal scholars, legal practitioners, students, and policymakers, the ILA Global Network and its regional and national branches contribute to the work of ILA research committees and on important topics of international law. ILA branches also hold biennial conferences. Last one was in Athens, and the next one is in Vienna in 2026. ILA organizes panels and workshops on a wide range of international topics of relevance, just like this one today. So with that, it's my great pleasure now to introduce ILA Canada's special guests. And first of all, we're really delighted to have a member, a very distinguished member of the American branch of the International Law Association. Indeed, he's the vice president. That is Peter Yu. He is Texas A&M University Distinguished Professor, Regents Professor of Law and Communication, Director of the Center for Law and Intellectual Property, and as I say, vice president of the American branch of the International Law Association, also known as ABILA. And he's a prolific scholar and an award-winning teacher. Peter is the author or editor of 9 books and more than 200 law review articles and book chapters. He has served as a general editor of the WIPO journal, published by the World Intellectual Property Organization. And he's an elected member of the American Law Institute and sits on the Science Advisory Board of Max Planck Institute for Innovation and Competition in Germany. You can find out more about him on his website, www.peteru.com. And he'll be focusing today on whether there should be a treaty on intellectual property and artificial intelligence. The next guest that I'd like to introduce is Constantia Kutuki. She is the Vice Dean, Graduate Studies at the Faculty of Law, Université de Montréal, and she's the former president of ILA Canada. She left big shoes for me to fill. She will focus on developments in Indigenous IP, specifically traditional knowledge and genetic resources. And finally, we have Marcia Simone Cadogan. She is a lawyer with MSc Intellectual Property and Technology Law, and she's a former vice president of ILA Canada and a current member of the board of directors of ILA Canada. She'll focus on IP and the development divide relating to intellectual property, ecosystems, and industrial designs, and the Design Law Treaty. So to start off, I'm going to ask you all one question and I'm asking for a quick response in about 2 minutes each. Could you please tell me, and I'll start with Peter, then go to Constantia, and then to Simone, can you identify one benefit resulting from the internationalization of intellectual property? And also please explain what you mean by IP's internationalization. Over to you, Peter.
So Una, thank you for having me over here. I think it's now a fact that IP is a very much of an international issue. I don't think that we can actually put the genie back in the bottle. I think it depends on where you're coming from. If you are coming from a country that exports intellectual property, I think it's a comparative advantage for a country so that it can promote economic interest. If you're coming from a developing country, I think it's important to think about why we set up the system this way, right? Why do we protect, for example, Parmigiano Reggiano, but not Basmati rice? Right? Do we have strong protection for biotech inventions, but not traditional knowledge, right? So I think it'll be important for us. And the last thing I'll end on is I think there's always the interplay between international law and comparative law. We can gain comparative insights by having international engagement.
Thanks, Peter. Constantia.
Well, I think, I mean, I agree with everything Peter just said, but if I take the Indigenous lens on this, I think it was positive. The internalization, and what we mean by it is basically what Peter said. You can't put the genie, as much as we would like to put the genie back in the bottle, we can't, it's done. You know, the most successful international trade agreement was one of its pillars, intellectual property. So it's kind of, it's a done deal. Now it's how do we manage it, right? And so from an Indigenous lens, it's been positive in the sense that we have been obligated, whereas before it was a bit of a go in, take and run situation. We have been obligated to go in, explain, and for the most part still run, but at least we have to explain what we're doing there, and which means that there is a certain amount of knowledge that has been passed on about the importance and the monetary economic value of traditional knowledge, which wasn't there before. So therefore you have communities and peoples that are now like, wait a minute, you mean you can actually place a monetary value on this knowledge, and are starting to build in systems to make sure that there is some economic, I guess, money or in other forms that go back to those communities. Whereas before, this knowledge was obligated to be done via international intellectual property law. No one said a word, and it was just taken back to wherever they came from. I don't want to say Western world because it's happened elsewhere as well. And economics was benefited in one place and the knowledge stays in one place. And now that has been sort of broken down to a certain degree.
Thanks, Constantia. Over to you, Marcia.
Thank you. So I agree with everything that's been said so far by Peter and Constantia. We live in a global economy where products are important, so are services. So if you are a creator, an innovator, and you're producing content or producing goods that are consumed by the market, you of course want to ensure that you have some type of exclusivity in terms of a period of time where you can market the product and be somewhat assured that if your product is exported to country A, B, C, D, there is at least a level of consistency in the types of intellectual property rights that exist to safeguard your product in terms of from infringements or unfair competition. So the internationalization of IP allows that to happen. It also, from the perspective of users, allows users such as ourselves being also within the consumer market space, the ability to access and use these intellectual property products on terms, of course, that are within the ambits of the law, the legitimate ambits of the law. This would not be possible without the internationalization of intellectual property. It doesn't mean that there are not challenges and issues. There are, and we will address some of those today.
Thanks very much, Marcia. Okay, and so now I'm going to turn to Peter to discuss in more detail his ideas about artificial intelligence and intellectual property.
So a while ago, I did a copyright seminar for the Copyright Office in the US, and the seminar is available on YouTube. For those who are interested, you'll be able to get it from there. And one question that has been asked all of the panelists is whether we see any convergence or divergence of developments regarding copyright and AI across the world. And at that time, it's actually quite difficult to actually decide because you can see convergence right here. And that was in July 2023. You can also see divergence. And on top of that, you can also see what I call cross-vergence. You got convergence in some places, and then you got divergence in other places. So what I want to do is to give you two sets of examples before I get into a discussion as to whether we are ready to have a treaty on AI and IP. So the first set of examples coming from an issue that has come up quite a bit about AI training. So the issue is about whether the use of copyrighted works to train AI models is actually legal or not. And in the US, we have more than 20 lawsuits. So on the slide right here, you can see different lawsuits. And one of the lawsuits that have captured a lot of attention, and I think have one of the stronger complaints, is the one filed by New York Times. And there is some issue with respect to what some have called memorization, whether the AI model can actually memorize what has been used for the training purposes. So a quick response for any litigation in the US is usually fair use. We do have very strong protection of fair use in a way similar to the fair dealing arrangement in Canada. And in the US, we do have different cases that are available. So iParadigm is about plagiarism detecting software with Google Books, with HathiTrust. So those are the cases that will support the use of copyrighted works for different purposes, including text and data mining. But we do have two new cases that just has been decided recently by the Supreme Court. One is very supportive of transformative use, and that's Google v. Oracle. And the other one is less so, and that is the Andy Warhol Foundation case. But the important takeaway here is that regardless of whether we look at the previous cases, whether it's from the appellate court or whether it's from the Supreme Court, the issue is really about input. It's not so much about output. So to the extent that we are talking about generative AI that can produce competing AI-generated creations, that is a somewhat new issue. We can apply some of the old cases and extend it to the new context, but at the same time, those who are on the plaintiff side, they can easily argue that those cases are not so relevant because they were decided before we have this type of situation. It's important to recognize that it's not only US that has fair use. There are other countries that have fair use or fair use-like protection. And on top of that, as I mentioned earlier on, we also have Canada, which has user rights. But if you go to other countries, the approach is somewhat different, right? So you can see that here you have the text and data mining exception in a lot of jurisdictions. UK and EU are often mentioned, the EU with respect to the Digital Single Market Directive. But the interesting thing is actually Japan adopted the text and data mining exception way back in 2009. It's still actually the broadest exception in the world, and it's also many years ahead of other countries. So if you look at Japan right here, what it says is that if you want to engage in anything that does not amount to the personal enjoyment of thoughts and sentiments expressed in the copyrighted work, that will be acceptable as a limitation exception. And so that will include testing of technology, data analysis, and also computer data processing. So this one is as broad as you can get in the AI context. There are some back and forth within the Cultural Council in Japan as to how they're going to interpret the Article 34 as well as Article 47.7. And here, this is basically the guideline that's recently posted in May 2024 from the Japan Corporate Office. The interesting thing, as I mentioned earlier on about the interplay between international law and comparative law, is that the interesting thing for Japan is we normally see legal transplant coming from the West to Asia. And this time we actually got a transplant coming from Asia before we got adopted in the UK and in the EU. It's not only Japan. Singapore amended the copyright statute during the pandemic, and this is the latest provision, Section 244, about computational data analysis. So this is similar to Japan, except that there are more conditions, for example, about lawful use, about how you can disseminate the content with others for sharing purposes. So it's more narrow than what you get in Japan, but at the same time, it's still very supportive of text and data mining, or what they call computational data analysis. But I think Singapore is actually a very interesting scenario. One, this is actually the latest we got with respect to TDM exception, text and data mining. The other reason is that Singapore actually has fair use. So if you want to compare with what the US has, to the extent that Singapore basically interprets fair use the same way as the US, then Singapore will have one additional exception for computational data processing. And so I think that would be quite interesting in terms of how we get into future development. That also goes to the discussion about whether we should have a standard similar to fair use, or whether we actually want to have a rule that's similar to the limitation and exception that we normally find in continental Europe. So when you look at AI training, there seems to be more convergence in terms of how different countries are approaching it with the understanding that we need to use copyrighted works for AI training purposes. They might have different way to address it, whether it's through fair use or whether it's through limitation exception, but there's some convergence right there. So Matthew Sack and I recently wrote an article, and that is available on SSRN for those who are interested. And we find that there's no international consensus at the international level, but there's an emerging equilibrium. And the reason why we find that there's an emerging equilibrium is that the distinction between idea and expression has been adopted in most countries, if not all countries. And you can find in the TRIPS agreement, which has more than 100 members. And then you can find it in the case law, you can find it in the legislation. And so when you're using the copyright work for non-expressive purposes, and there's expectation that you'll be treated differently than when you use it in expressive purposes. And of course, when you talk about generative AI, you also have the interplay between whether this is actually expressive or whether it's not non-expressive. The second set of examples I will share with you is about the copyrightability of AI generative work. So if you go to a compendium of the US Copyright Office, which is used to examine copyright works, you can see that a work must be created by a human being. And that compendium was actually revised after the monkey selfie case. So this monkey from Indonesia was able to take a photo of himself, or her, actually, I think it's herself. And then the issue is whether this macaque was able to actually become the copyright holder. And the court has decided that, well, Naruto, which is the name of the monkey, should not be the copyright holder. And based on that decision, as well as the compendium, and on top of what we have in the Constitution about what is considered as an author, the Copyright Office have rejected a number of widely reported works. So on the left-hand side is Stephen Theller's A Recent Entrance to Paradise. On the right-hand side, you got the comics developed by Chris Constantinover and Sorry of the Dawn. And on the bottom right-hand side, you have an image that actually has won an award at a Colorado State Fair. Everybody's very happy until they find out that it's created by AI. And on the left-hand side, you got artwork created using an Indian system, and it's called Sirius. And that's the combination of both a photo of sunset as well as the painting from Van Gogh. And the idea is to actually have it in the style of Van Gogh. But all four of them has been rejected. If you're interested, the decision by the Copyright Review Boards are available on the Copyright Office website. and they will explain why they rejected the application for registration. So far, there's only one case that's gone all the way to a district court, and that is for the first one I mentioned by Stephen Thaler. And for those of you who are into patent law, you also know that Stephen Thaler was involved in a lot of the so-called database cases around the world at the European Patent Office, the USPTO, in South Africa, Australia, as well as other places. It's not only so when you look at what's going on in the US there, and a good contrast is actually what's going on in China. So in China, there are two cases that are very famous with respect to copyrightability of AI generative work. The first one is the Tencent case, and the case involved basically a report of financial news that was automatically generated by the robot called Dream Writer from Tencent. And the issue here is whether this is actually protectable, and the court found that based on arrangement and selection by the plaintiff's creative team, which consists of human beings, and based on the data input, triggers, condition setting, template, and choice of cover style, those are intellectual activities that are within the meaning of Article 3 of the copyright law.
Peter? Okay, something's happened to Peter. Peter, I think you, is it just me? Is anyone else noticing that Peter has frozen?
He has, in fact, frozen.
Yes, I think what I'm going to do, Peter, because it seems like a very long, oh, is he back?
I think he's, hold on.
Okay. Peter, he's coming back in. Peter, you're on mute.
Okay, so
Sorry, you froze for about a good minute.
a good minute. Okay.
Can you go
Then
back over? You just done the
this one?
the robot, you're not,
Okay.
you talk about consent robot, yeah.
Yes, okay. So this one is created by the robot, as I mentioned earlier on. And so what the
Sorry,
court has decided is
I've got a question. Do you want to add your slides? They're not showing anymore.
oh, sorry.
No problem.
Yeah. So that happens with Zoom quite often. So we get used to it. Let's go back to the case right here. So this one is actually written by a robot Dream Writer. And so what the court has decided is that, well, based on selection arrangement, this one is actually done by the plaintiff's creative team that consists of human beings. And so if they look at the trigger condition setting, data input, template, choice of cover style, that will constitute intellectual activities within the meaning of Article 3 of the copyright law in China. The other case we got is the latest case by Beijing Internet Court, and that is about the image created by Stable Diffusion. And the decision is basically the same, based on selection arrangement, that is protectable. But more importantly, the court went further to say that, well, looking at how after providing initial prompts and parameters, the plaintiff, the human plaintiff, continue to refine the image until they got the final image, right? So to the extent that we are asking for human creative input, we do have a lot of human creative input. And the court also include the prompts and parameters at the decision. This is actually the first decision I've seen where you actually get a prompts and there are some typos here and there, but at the same time, you understand what they're trying to do with respect to human creative input. It's not only just China, but also in other countries. For example, Korea is now trying to explore whether they can adopt a different legislation. For example, providing protection for 5 years after public disclosure, just not as long as what you normally get, life plus 50 in the copyright system in different parts of the world, or life plus 70 in the US, but it's 5 years after public disclosure. I could not find more information about the latest development about this proposal, but at the same time, other countries are trying to go in that direction and offer sui generis protection. So when you look at the issues here, there seems to be more divergence, right? There's difference between what's going on in US and what's going on in Asia. And the question I love to ask people is, if other countries are starting to offer, let me go back. If other countries are starting to offer AI generative work, should we follow suit in the US, right? So the safest answer in law school is basically yes and no. And this is actually the correct answer. We have in the US, we have rejected adopting similar legislation likewise in the other countries. So a good example is how the US insists on not offering sui generis database protection despite the EU directive. But at the same time, the US has also changed its law based on the TRIPS agreement. We have extended, we actually changed the patent term. We've restored protection to some of the copyright works that have gone in the public domain. Before we adopted the TRIPS agreement, we also adopted the intent to use in the trademark area. And so we do follow the models in other countries sometimes and rejected them at other times. There's an interesting discussion among both practitioners as well as academics is that whether we can actually focus on whether the work is AI generated or whether it's human generated. And if we're using AI as an assistant, then it should be treated differently. And my view is that this is actually an outdated view. It's not going to work very well because as we move forward, especially with all these generative AI tools like ChatGPT, Midjourney, Stable Diffusion, some people will use AI more than others, right? So some works will include 30% human input and then 70% AI input. Other works will include 70% human input or even 90% human input and less so for the AI, right? So we're in a hybrid situation where people will use AI for some purposes, and it's very hard to figure out whether this assistance or whether this not. And in the future, I think a lot of countries will have to grapple with this issue as to at what point the human creative input has reduced so much that we actually will not find it sufficient for copyright protection. And I think different countries will actually come to different conclusions. And I love to use this slide to get people to think about, well, assuming we are in the future, similar to Star Wars, whether drones can be traded with others, and you have an AI system that's 3 owners. The first owner designed the AI system as a self-learning algorithm. The second owner selected and inputted data to train the AI system. The second owner doesn't need to redo the algorithm because it's a self-learning algorithm. You will write the code itself. And then the last owner just got the AI system in the last year. Who should own the copyright work created by this AI system? And those who actually go for the first one, and they basically have similar laws in the UK, in New Zealand, in, I believe, Ireland. So there are a number of places, Hong Kong as well, where you actually get provision saying that the one who is actually necessary for the creation of the computer generative work will be the owner. Those who go for number 2 is believe that data will be the king, will be very important for protection. And the last one is actually what we have today. If you write a paper using Microsoft Word, Microsoft will not own the copyright in the paper. You own the copyright in the paper. Of course, you can also go for all 3 of them and use smart contracts or other ways to actually assign basic royalties or ownerships, right? So there are different ways to do it, but I believe different countries will end up with different conclusions. So how can we chart a better future? And that's the last part of the presentation. The first way, obviously, is treaty. When people think about international IP, they always think that, well, let's think about whether we can have a treaty or assume there's a treaty. And I think it's going to be very difficult. We look at what's going on during the pandemic. We're trying to amend a provision of the TRIPS agreement. It was not very successful, and we still have ongoing discussion about the pandemic treaty, and that's also facing challenges as well. If you look at what's going on in WIPO, you can see on the slide right here, we just got a new treaty on IP, genetic resources, and associated TK. That was in May 2024. And at the moment, WIPO is negotiating a design law treaty in Saudi Arabia. But if you look at the slide right here, these are all the treaties that have been adopted by WIPO after adoption of the TRIPS agreement. We got about 2 or 3 treaties, and then we have a year, about a decade of no activities, and then we resume, and then we have another decade of no activities. So my pessimistic view is that after the TK Treaty and the Design Law Treaty, maybe we have one more, or maybe we will not have none, and then we have a decade of not much activities, right? So treaty development is actually very difficult, whether it's you talk about WTO or WIPO. And I think AI is actually quite different from, for example, a TK Treaty. This one is much broader. It covers so many different issues. The TK Treaty focuses on disclosure, so it's much more narrow, but AI involves international trade, involves national security, and I think that's going to be quite challenging. It's also quite challenging because a lot of the powerful countries have different views on how they should have technology regulation. So Anu Bradford is known for her work about the Brussels effect, but her new book, Digital Empires, compared the efforts to develop technological regulation and exert global influence by China, by EU, by the US, right? So we see that there's been a lot of disagreement over what's the right standard at the international level on privacy, data localization, digital trade, and I think that will continue into AI space. There are also the race to AI. I think there's a big issue for all different countries. So on the slide, I include the 3 countries mentioned, but obviously many other countries are now joining the race. During the pandemic, we have seen what you should describe as vaccine nationalism, but then in the AI space, we may also see AI nationalism. The second option is to rely on soft law recommendation. And so we do have a number of examples. For example, WIPO has a joint recommendation on well-known trademarks, and that's one example. The Doha Declaration is another example of a soft law recommendation, and that has eventually become a hard law in terms of the Article 31 bits of the TRIPS agreement, and that's been ratified a few years ago. And the last example I show you is Universal Declaration of Human Rights, which has now becomes customary international law based on the interpretation of many countries. And so you can have soft law, but have very impactful. And I think the UDHR is a very good example. Third option I'll share with you is the multi-stakeholder dialogue. And so I've seen a very good example coming from the Internet Governance Forum. I think APAC is another good example coming from Asia. When Francis Goury, the former Director General of WIPO, was trying to offer a suggestion as to how WIPO can help with a lot of the issues about internet streaming, he proposed that WIPO can actually set up a multi-stakeholder dialogue to create a global legal digital marketplace. And so he believes that we're not ready for a treaty, but at the same time, WIPO can actually play some useful role. And I think AI is actually one area that we need to have more discussion about what's going on there. And the last example I'll share with you is basically the use of trust of law principles. And so assuming that US will take a more isolationist approach, I think a trust of law principles can be very useful because you can allow courts to bring in international developments through trust of law principles. And so the International Law Association obviously is very active, and they have developed the Kyoto principles during the pandemic. But the American Law Institute, as well as Max Planck, has also developed different principles. So trust of law principles could be quite useful. So let me end on what I'm very concerned about, as well as what's my biggest fear. My biggest concern is that we are looking at this type of developments very narrowly. We're thinking IP only about IP, but forget that IP is also about national security and also about international trade. And for those of you who care about the environment, AI also has raised a lot of issues about environmental impact. So IP and AI has to look at it broadly. But my biggest fear is also somewhat contradictory in this way. My biggest fear is that we are going to fold everything about AI ethics into IP law. There are a lot of legislation we need to have in the AI area, but IP is just not the place. So I'll stop here, and I'm going to turn it back to Una.
Wow, thank you very much for that, Peter. There's so much to think about. And we'll move on to hear more about Indigenous people's rights and traditional knowledge issues, which I think Constantia can tell us about now. Thank you.
Thank you. And a year ago, I did a conference on the use of AI to document Indigenous traditional knowledge. So a lot of the things that Peter just said resonated to a large degree. So today I was asked to talk more about sort of advances in the international intellectual property law with regards to Indigenous people. And again, as Peter just said, you know, the advances on this and other international intellectual property law sphere in the international forums is very, very slow. So we have recently, so basically in May, June of 2024, a treaty called the Treaty on Intellectual Property, Genetic Resources, and Traditional Knowledge, which, of course, a lot of people got incredibly excited about. And I can understand why they did, because it's 25 years in the making. So if you've been working on something for 25 years and you actually ended up with something, gave birth to something, you'd be, you know, excited about it. You know, I'm a little bit less excited for it. I've been researching this area for, you know, longer than they have been trying to get this treaty together. And I'm trying very difficult with a lot of difficulty to see sort of the big difference between what we find in the Nagoya Protocol, what we find in the Convention on Biological Diversity, what is already sort of splattered here and there in international law, to sort of see the great leap forward. And I think basically the great leap forward is to sort of take all those particles and put them in one place, rather than some sort of big legal advancement. Obviously, as Peter mentioned, the idea of disclosure is important. But we've had that remnants in various other instruments before. And now, of course, it's sort of become a focal point, as opposed to it being here and there. It's become a focal point where this treaty obligates various stakeholders to disclose where the genetic resource came from and if it's associated with some sort of traditional knowledge. And of course, the issue here is if the stakeholder, or let's say the patent applicant, sort of says, well, I don't know where it's from, I'm not able to trace it, there is sort of forms that they can fill to say that, to my best, to my knowledge, I don't know, which kind of sort of takes away this obligation to go and find out. Like, you just have to know where it comes from, or you can't do this sort of patent application. So just to go back a couple of steps, in Colombia in 1999 made this proposal official in the international arena under the WIPO auspices. And since there has been so much negotiation, so much energy, so many efforts to make this a reality. And like I said, we got it in May of 2024. And of course, now what we have to wait and see is who is going to adopt international law, this treaty, who is going to actually make it a real reality, if we can say that. Because, of course, this agreement of 150 states to say, okay, we have here something we more or less like, does not mean we will adopt it fully and completely, you know, into our national laws. Of course, it only needs about 15 states to do so before it sort of takes on another level in international law. But that, of course, depends on who those 15 countries are. If the 15 countries that say, okay, which we've seen before, are 15 countries that have very little stake in genetic resources and Indigenous traditional knowledge, then it's not going to have the impact as if those 15 countries are countries with high population of Indigenous people, with a high level of genetic resources and a high level of a combination of both Indigenous population and genetic resources, and of course the traditional knowledge that goes with it. So if we have Canada, the United States, New Zealand, Australia, Brazil, Colombia, Mexico, India, some of these big mega diversity areas, as we like to call them, that sign on, that is going to be one thing. If we have, like I said, countries that, and we've seen this before with other treaties, where it's not going to really impact me, so I'm going to sign on because at the end of the day, it looks good. On a marketing level, it looks great. I say we signed, but it doesn't really impact my internal ways of being or doing. So the sort of strength that this treaty has is, again, the whole idea of disclosure. And the disclosure is a little bit wider than it was before. So it includes very explicitly microbial type biodiversity genetic resources. So in addition to animal and plants, again, microbial has been talked about here and there, but this has been made a focal point. And as most of you know, whoever knows me knows that soil is my absolute favorite natural resource that exists. So for me to see microbial and microorganisms take such an important place is quite important. The other thing that, if I can just sort of come out of law for a second and join my, other self, and sort of discuss the fact that what this does, using the kind of language that we see in 2024, as opposed to what we saw in the TRIPS agreement and in other agreements that talks about Indigenous people, even the Convention of Biological Diversity, you see this sort of becoming closer. The language becomes closer between traditional knowledge type language that we used to see in the past and science, like real science, which of course I don't make the distinction. They are both science using different mechanisms to arrive at the conclusions. There is no one more science than the other. Anyway, the language that is being used, you see this closeness in that I think there has been an acknowledgement on the part of laboratory science to sort of say, okay, we spent forever saying that depression, mental health, all of that is this chemical imbalance in the brain, the serotonin and all the rest of it that is not in balance, and therefore that's what you have, and all you have to do is sort of bring in that artificially, that balance, and you'll be fine, which of course never worked. It didn't work, and we couldn't understand why it worked. And as much as traditional type medicine would say, look elsewhere. If you have a problem in the brain, you don't look in the brain, you look elsewhere. Now we know what we have to look at is the gut, because the microorganisms in your microbiome that is there has an important, enormous influence on how your brain is going to function. So all those microorganisms are incredibly important. So out goes the pharmaceuticals and all of the other places, digging up soil and all sorts of things to try and find some of this microorganisms that are so critically important in terms of mental health, of course, other physical health as well, but specifically mental health. And that has brought together these two ways of doing science. And you see that language now being translated into law speak, which for me is really important and an exciting sort of development. And I'm going to end on this because I know we're running out of time. The sort of a negative part to this treaty is, of course, that in my opinion, it just doesn't have that leap that we would really have liked to see beyond what we can find in the Nagoya Protocol or the Convention on Biodiversity or in other treaties in international law that talk about Indigenous knowledge and intellectual property. And that is too bad, because I would have thought after 25 years of actual negotiations and, so much like officially in international law, Indigenous people brought this up in the 60s, right? So, that has been in the conscious of international intellectual property lawyers for decades and decades, and to sort of arrive in 2024 with what we can deem as a great initial step into an actual treaty, but not what we would have hoped for, because that initial step I would have loved to have seen 10, 15 years ago, and today I would have liked to have seen something more. But you know, it's a good step forward, and I think we'll leave it at that.
Thanks so much for that, Constantia. Very interesting. Let's turn now to Masha to hear about ideas about the development divide.
Thank you. We've been having such a great, interesting discussion so far. So thank you to Cassandra and to Peter, and of course to Una for hosting the session. Very briefly, I'd like to talk about IP treaties, the ecosystem, so now the domestic or national ecosystem in which these treaties operate when they're ratified into domestic law, and the development divide. And I'll focus specifically on industrial designs for two reasons. It's one of those types of IP forms that is not really utilized that much as it should. And secondly, because of the WIPO diplomatic conference that is going on now, which hopefully will lead to the signing of a design law treaty. Now, in terms of the development divide, it's a concept, it's a situation that we've heard about for decades in terms of the fact that intellectual property, in terms of its benefits, these seems to be more realized and more capable of being realized and achieved in a developed economy as opposed to a least or developing country. And there are many various factors that are responsible for this situation. Now, of course, within this, there have been developments that has been going on since TRIPS. Peter spoke about certain treaties that have been signed so far. I would like to talk about, well, what about industrial designs? Why is it that it's hardly part of an intellectual property basket? So when I say intellectual property basket, I'm referring to the types of IP that a business uses to safeguard the proprietor interest that it develops or that is assigned to it. So a lot of times you'll have the trademarks, the patent, the copyright, the trade secrets, but not so much industrial designs. And one point that makes this clear as well is in the recent IP statistics released by WIPO concerning the filings data for industrial designs, China accounted for over 882,000 industrial design filings for last year, and the second country way below China was the US for 60-something thousand. Now that's a big difference. Now, speaking about this from the developing country perspective, it provides an opportunity. Why is it not being taken advantage of? Now, very quickly, what is an industrial design? It covers the ornamental, non-functional features of a product, so that is produced in mass quantities. It's being applied to cars, furniture, packaging, some type of phone designs, phone handling, used in the manufacturing industry. So many different ways that this type of IP can be used. And in terms of the treaties that are associated with the commercialization of industrial designs, and the Hague system allows one application. So if you're an innovator or a business who owns who is applying for an industrial design, you can use the Hague system to fill out one application form for registration in multiple countries, as long as that country is a member of the Hague system. It is of course a procedural mechanism. So what the International Bureau will do is, once they get the application, is check it for formalities. It's forwarded to the different IP offices, and if it is not examined or processed within a certain time, then the applicant has an international registration for the protection of industrial design. What it does is, of course, it gives you between, say, most countries is 10 to 15 years of protection, some a bit higher, where you can make, import, export, license the product that embodies the design, of course, for the benefit of your firm. So the question then says, you know, it's more of a question, why is it not being used so much by developing countries? And if it is being used, why is it just by big firms such as Samsung and so on? And that leads to the types of innovation strategies that the firm uses. Talk about innovation strategies, the focus then is also on the law. So whether or not system, the type of treaty, Cassandra spoke about treaty, that the design law treaty will embody. Is it about disclosure? Is it about grace periods? Does it protect traditional knowledge? Because a part of this design law treaty speaks to the fact that if the design that is embodied within the product is a traditional knowledge or comes from a traditional cultural expression, again, coming from Indigenous peoples and local communities, it has to be publicly disclosed, and there should be a mechanism available in each country to oppose the design, so it being embodied in that product. So which is great, of course, for Indigenous people, but let me take this one step back to talk about the innovation strategy and the conduciveness of the national or domestic ecosystem to the use of industrial designs, for one. And this then brings to focus the importance of having the appropriate laws. So the law that recognizes industrial designs, the ability or capacity building. So that's important as well in terms of whether or not the innovator or that startup even knows about industrial designs, and the fact that there is a system out there wherein international registration is possible. When we then think about what's going on now with the WIPO Diplomatic Conference and the signing of the Design Law Treaty, the question then comes to, if it does come into force, who will be party to this treaty? What type of impact will it have in the jurisdiction, including in developing countries? Will it be a situation where, if it is ratified, it's a part of the statute, it's a part of the IP law, but that's it in terms of its usage, is to a minimal level. There is not significant awareness about the treaty and its benefits. Indigenous groups are not aware that this treaty exists, or there is no real collaborative network that makes it possible to oppose an existing or pending design application. So what then does this mean for any type of policy that is focused on bringing synergy between
So Marcia, your sound is breaking up. Maybe turn your camera off. Marcia?
That it's
sorry,
that we're not able.
Sorry. Can you hear
Yes.
me? It's doing it. Your sound was breaking up, but you're okay now, if that's okay. Otherwise, maybe turn your visual off if it's a problem.
I'm okay. I will turn my camera off a little bit just to make sure that I don't lose anyone. I'm ending. Right.
Okay.
So then these are issues that need to be addressed when we think about the connections then, so to speak, between treaty ratification and its implementation into policy within developing countries and also within developed countries too. These are conversations that needs to be revisited in regards to the narrowing the gap between IP and the development divide. I'll end the discussion there.
Thanks so much for that, Marcia. And And we actually have one question in the chat, so I'm going to read it to you, and hopefully one or all of you can make some response to it. The discussion around the ownership of IP rights in AIGC is currently a hot topic. The training data, which serves as a foundation for AIGC, is primarily controlled by internet giants, often exceeding the regulatory scope of individual nations. So how should the rights to these foundational data sets be defined? Thank you. So I guess it's an artificial intelligence question. Maybe I start with you, Peter.
Yes, sure. I think the standard response is that we need to have stronger protection under competition law or antitrust law to address a lot of those issues. I think the difficult issue is that right now the focus for both IP law as well as, to some extent, the antitrust law in the US has been on those companies that have been using copyrighted works without authorization. And the fear is that if they focus so much on those companies that do not have authorization, then they ignore the fact that some companies like Matter, like Getty, they already have a lot of data that they can use for training purposes that they do not need authorization, right? So to the extent that you're concerned about those companies becoming bigger, the focus on those companies that have used data without authorization will actually help make those companies even more powerful, right? So that's one concern. The other one is ties into something Marsha talked about a development divide. If you look at the cost of foundation model, think about, for example, OpenAI is easily over 100 million, right? So in the future, it'll be at least $1 billion because the companies need to have more and more training data. And by now, it's already quite clear that a lot of countries in the developing world will have no chance to actually develop their own foundation models, no chance to develop this type of AI technology. Then the question is, where should we go, right? Should we actually think about other options? Should we think about technology transfer? And this is actually something I'm working on at the moment, trying to figure out how to bridge the global AI divide. I think that's a very important issue. And the last thing I'll end on is that we are focusing so much on the current model based on large language models, but there's already more and more research about, for example, synthetic data, about small language models, right? About open source training sets, right? So there are different ways that may actually change the ecosystem of the AI sector in the future.
Thanks, Peter. Constantia, did you want to comment on the question or say some closing remarks?
Yeah, if I could comment on that question, please.
Yeah.
So I'm going to go back to the Indigenous situation in that there is a couple of sort of big data AI projects going on in terms of the collection and the categorization of Indigenous knowledge, and not just knowledge, but also language, customs, even DNA, et cetera, And the big issue here is twofold. One, of course, is the same issue that Indigenous communities and nations have with their knowledge, in that they don't have control of what happens to it once it leaves. And it's the same thing here. You have this sort of big projects with big data and AI involved, trying to place and put in little boxes where they think different aspects of ITK belongs without the cultural context, which of course is very frightening to Indigenous communities, because taken out of context, it's really not beneficial to the communities. And the second aspect is, when I did my research on this, like I said, I did a presentation last year. One of the things that really marked me is the fact that there is, in all of North America, so Canada, US, and Mexico, 4 Indigenous people of Indigenous heritage that have the technical capacity to work in the front end of AI, i.e. in the development and in the design of the AI, and how that AI is going to then go out and deal with this information. So you have this sort of colonization in addition to colonization, sorry, the French is trying to come out, but I won't let it, on top of colonization, in the sense that the AI is already programmed in its way of doing, and the data that is being used to train it is in no way related to the context of Indigenous people. And there's only 4 people in the entire North America context that could, if they wanted to, of course, they're working in other areas at the moment, partake and have this little input. And that is rather frightening from an Indigenous perspective.
Yeah, a really interesting point. I think this connection between competition policy, colonization, yeah, it's very interesting in the AI context. Masha, I don't know if you want to turn your camera on again and say some last words, or if you'd rather keep the camera off just because of the.
Thank you, Una. I think I'll keep the camera off because I do not want to lose connection. So that's the only reason why I'm not on camera, because at one point I was not. It's a challenge to talk about this from various perspectives. And I think it's important what will make the difference is informed policy choices, informed by having the right key stakeholders being involved in the conversation, being at the table. And even so, it's difficult.
It's true. We have one last question. Is it possible to consider DSI as derivatives or accessories of, oh my gosh, too many acronyms, GR? Yes. So they could fall in the scope of the new WIPO treaty. What is DSI first?
Digital sequence information.
Thank you. And GR?
Genetic resources.
Genetic resources.
Okay, good. All right. Now we've got the terms out. Is that a question that somebody here would like to answer?
Yes, yeah, it's going in that direction, obviously, right? This is another genie question in the it's already out there. So digital sequence, I'm not going to go into what it is and how it works, because clearly we're past time. But digital sequence information is used in two ways in genetic resources. One is the actual genetic sequence of various genetic resources and how that information is being used, cataloged, categorized, and ownership questions that go with IP. And of course, now we're in the situation of how this information is going to be used via AI or some other, not necessarily fully AI, because we haven't really defined what we say as AI here, right? Because AI, now we're kind of putting everything in the kitchen sink into the definition of AI, and it's not necessarily the case. So you've got AI, but you also have sort of sub-AI or AI-like mechanisms or digital ways of doing that is able to take that information and do all sorts of things with it. So there are questions of ethics here. This is particularly important in the biotech industry, but for my part, this is also very important in terms of the Indigenous local community context, the cultural, spiritual, particularly the spiritual aspect. Because if you're taking and you're decoding someone's God via machinery, and then you're doing all sorts of things with it, what does that mean for that nation, for that community? And so we also have to really define what we say with regards to spiritually and God. We get offended when our own personal God is treated in weird, wacky ways. But if a plant, let's say the ayahuasca or some other plant like that, is God-like or God in various places in terms of its spiritual value, what does it mean to have it broken down in its little tiny pieces and then put back together in weird and wacky ways, which is great for, scientific sort of curiosity. But we want to think of the spiritual importance of these things as being more important than scientific curiosity. I'll stop there. Sorry.
Yeah, thank you very much for that, Constantia. And it does seem that we could do a whole, second hour on issues around sequencing of genetic information.
I think Peter might have something to say on that as well.
Yeah. Well, what I think I'll ask you to do at this point, the three of you, could you do a quick wrap up? And if there's some idea you'd like to really leave with the audience, please bring that into it now. Any ideas about the future? I'll turn to you first, Peter.
So I think I will share with you guys one dilemma that I could not address, and that will also help tie the three presentations together. If there's an elder from an Indigenous community coming to me and asking me whether they should opt out from allowing the works for training purposes, the logical response is that they should, right? They should be able to determine how the information is being used. They should determine whether they will be able to control whether you'll be used out of context. The drawback of that approach is that if you opt out, then AI will hallucinate. They will rely on the content that's actually provided by non-Indigenous community. So the harm is that it can be equally problematic if they actually opt out and not allow the work to be used for training purposes. And so far, I cannot come to a good answer with respect to whether they should actually opt out or whether they should not opt out and allow it to be used in a way, even though they might lose control.
Mm-hmm. Yeah, it's a fundamental problem that hasn't been fully resolved yet, isn't it? Masha, would you like to say your last words?
Yes, of course. Thank you. And this speaks, of course, to the conversation that each of us have had today, the future of international intellectual property. We can see that it is important, but in terms of its ability to make significant changes to innovation and impact growth, whatever we define growth to be, because growth is not just economic development. There's so many different aspects of growth. In terms of its ability to impact innovation and make sustainable changes where growth is concerned, depends, of course, on the ecosystem and the conduciveness of the ecosystem to IP. So here, of course, we're concerned with the types of laws in place. So whether this be industrial designs related, whether it be the patent system, traditional knowledge, laws related to copyright and AI, but also, of course, apart from the laws, in terms of registration, enforcement, the types of incentives that exist for startups and for more established firms to actually remain within the jurisdiction to develop and, of course, to market their products. You see this happening all the time in developing countries, in some developing countries, and you even see this happening in Canada. So as much as the international legal framework is important, there's a lot of work that needs to be done domestically, so within the jurisdiction itself, to ensure that there can be a sustainable linkages between intellectual property, the concept, and the law itself, and whatever type of product, services, and of course, the owner that develops these.
Thanks for that, Masha. Constantia, did you have a last word you'd like to make at this point, or have you given it?
Well, last word would be, it would be nice if at some point we, in intellectual property and of course in all our other areas concerning Indigenous rights, to not confuse consult with consent. So even in this final treaty, there's nothing in there about consent, and Indigenous people do not have any what we consider consent in law or in other areas of law. We would never take what we do with Indigenous people as actually meaning legal consent. And so whether we're talking about the Convention on Biological Diversity, Nagoya, the new treaty, all of them, none, absolutely none, give Indigenous people the right to actually withhold and say no. They can negotiate the way that access can happen. And that's debatable, but it's there. So that is there. But they cannot just say, no, sorry, we're not going to offer the resources found on our territory, and we're not going to offer our knowledge. Go away. And that, to me, I'm still waiting for that day.
Yeah, thanks for that, Constantia. Important point. Well, thank you to our wonderful panelists. We've come to the end of this webinar. So I'd like to thank our speakers, Peter Yu, Constantia Kotuki, and Marsha Cadogan, for providing so much useful information and raising so many important questions. I thank the audience for your attention and your probing questions. And I'm really happy that we were able to do this, thanks to Marsha and Peter, to have this collaboration with the American branch of the International Law Association. That's just a lovely thing to do, and hopefully we'll do it again soon. Please follow ILA Canada and ILA, and also ABILA, on respective websites and social media for any upcoming events. You're most welcome to join the exciting and supportive international law community we have. And ILA Canada does offer free membership for students, so that may be an incentive for you. Anyway, thank you again to the audience and to our wonderful speakers, and have a wonderful afternoon, everybody. Thank you.
Bye.